Hello everyone, I Dr. Varun Kumar, Faculty of MBA Department from Tecnia Institute of Advanced Studies. Today I am going to deliver a lecture on concept of independent directors. In India, the gravity of independent directors was recognized with the introduction of corporate governance. The Company Act 1956 do not directly talk about IDs as no such provision exists regarding the compulsory appointment of IDs on the board. One of the section of the Act 2013 is section 149, which also deals with the appointment and qualification of independent directors on the board of the company and their importance in good corporate governance in the company. However, the same section has not been implemented till date and will come into force as may be notified in the Gazette. The Company Act 2013 has specifically defined the roles, duties, liability and the manner of selection of independent directors in board and various committees of the company, which are as follows. Now we will discuss an overview of independent director. The need of the independent directors arose due to the need of a strong framework of corporate governance in the functioning of the company. There is a growing importance of their role and responsibility. The Act 2013 make the role of independent director very different from that of executive director. An independent director is vested with a variety of roles, duties and liabilities for good corporate governance. The Company Act 2013 makes the role of independent directors very different from that of executive directors. An independent director is assigned with a variety of roles, duties and liability for good corporate governance. He helps a company to protect the interest of minority shareholder and ensure that the board does not favor any particular set of shareholders or stakeholders. The role they play in a company broadly include improving corporate credibility, governance standard and the risk management of the company. The whole and sole purpose behind introducing the concept of independent director is to take unbiased decision and to check various decisions taken by the management and majority stakeholders. And ideas bring the accountability and credibility to the board process. These independent directors are the trustees of a good corporate governance. According to NASDAQ, independent director means a person other than an executive officer or employee of the company or any other individual having a relationship which in the opinion of the issuer board of directors would interfere with the exercise of independent judgment in carrying out the responsibility of a director. According to the Company Act 2013, the Act 2013 has adopted many of the provisions of Clause 49 of the listing agreement and has defined the term independent directors, which says that independent director means an independent director as referred to in subsection 5 of section 149. The new act, along with the definition of independent directors, also provide the criteria for appointing, qualification, tenure, remuneration and liabilities of independent directors. Now we will discuss the manner of selection and appointment of independent directors. Under the Act 2013, strict eligibility criteria have been laid down for the appointment of independent directors. For example, an ID should not be related to the company or its holding or its subsidiary or its associate company. He himself or his relative should not have or had any monetary relationship or contract with the company or its holding or its subsidiary company during the current financial year. He also has to declare to the board that he is independent at the time of his appointment and also whenever there is a change that may affect his independence. Both the company and the independent director shall accept the provision of the Act. Also, the appointment of independent director shall be approved at the meeting of the shareholder and the explanatory statement attached to the notice of the meeting for approving the appointment of an ID shall include a statement that in the opinion of the board, the independent director proposed to be appointed fulfill the conditions specified in the Act 2013 and the rules and the proposed director is independent of the management. The Act 2013 has described the manner of the procedure for selection independent directors under section 150. This section says the selection of ID shall be done from a data bank maintained by anybody, institute of association, as may be notified by the central government, containing names, address and qualification of persons who are eligible and willing to act as an independent director. It also says that the appointment of independent director shall be approved by the company in general meeting and the explanatory statement indicating the justification behind appointing such person attached with the notice of general meeting. Now we will discuss role and duties of independent director. The role of independent director is considered to be of a great significance. The guidelines, role and function and duties, etc. are broadly set out in a code described in Schedule 4 of the Company Act 2013. The code lays down certain critical functions like safeguarding the interest of all stakeholders, particularly the minority holder, harmonizing the conflict interest of the stakeholder, analyzing the performance of management, mediating in situation like conflict between management and the shareholders' interest, and etc. The code also lays down certain important duties like keeping themselves updated about the company and the external environment in which it operates, not disclosing important and confidential information of the company unless approved by the board or required by law, actively participating in committees of the board in which they are chairperson or member, keeping themselves updated and undertaking appropriate induction and refreshing their knowledge, skills and familiarity with the company, regularly attend the general meeting of the company, etc. Now we will discuss the concept of meetings and committee. The Company Act 2013 require all the independent directors to meet at least once in a year. The meeting must be convened without the presence of the non-independent directors and members of the management. An independent director would also evaluate the performance of the chairperson of the company. Also, the Company Act 2013 require an independent director to review the performance of the non-independent directors and the board as a whole of the company. These measures would immensely aid in ensuring the smooth and proper functioning of the board of directors of a company. According to Company Act, has also emphasized on the appointment of independent director as a member or as a chairperson in various committees. For instance, in the audit committee, which shall comprise of minimum 3 directors, independent directors should form a majority. In the same way, the nomination and remuneration committee, which shall consist of 3 or more non-executive directors, independent directors should not be less than half of the total number of members. For the stakeholder committee, the board of directors of the company, which consists of more than 1,000 shareholders, debenture holders, deposit holder and any other security holder at any time during a financial year, shall constitute a stakeholder relationship committee consisting of a chairperson who shall be a non-executive director and such other members as may be decided by the board. Now we will discuss the liability of an independent director. According to the Company Act 2013, has sought to be balance the wide nature of the obligations, functions and duties imposed on an independent director. The Act restrict and limit the liabilities of independent director to the matter which are directly relatable to them. Section 149 limits the liability of independent director only in respect of act of omission or commission by company which had occurred with his knowledge, attribute through board processes and with his consent or convenience, or where he had not acted diligently. Nominee director, despite not being considered as independent under the new definition, would nevertheless be eligible be immunity as long as they are non-executive. At the end, we will discuss conclusion. What are the conclusion? The new concept of having independent director is a welcome step for corporate governance in India. The Company Act 2013 has conferred greater empowerment upon independent directors to ensure that the management and affairs of a company is being run fairly and smoothly. But at the same time, greater accountability has also been placed upon them. The Act 2013 empower the independent director to have defined say in the management of a company, which would thereby immensely strengthen the corporate governance. However, it is also important to keep in mind that good corporate governance is not just the outcome of appropriate selection and effective functioning of IDs. Every director, whether independent or non-independent, executive director or non-executive director, has a distinct role in the functioning of the company. It is only when the entire board functions effectively which result to good corporate governance and benefit minority as well as majority shareholder in its long term, which maintain a good corporate image in the market.